Good afternoon, everyone. We're going to make a start at the October plan meeting. I'll hand over to Pontius here to read out the notice and summons of meeting. Thank you.
Good afternoon, members. You are hereby summoned to attend the monthly meeting of the Planning Committee to be held in hybrid and in the Council Chamber in Guildhall, Derry on Wednesday, the 2nd of October, 2024 at 2 p.m. Alderman Keith Kerrigan.
Run on it. Please run on it.
Thank you. Alderman Neary McMorris.
Here.
Alderman Janice Montgomery.
Here.
Councillor John Boyle.
There's one on it, Chair.
Councillor Caroline Devine.
Shaw.
Councillor Sean Fleming.
Shaw.
Councillor Paul Gallagher.
Shaw.
Councillor Christopher Jackson.
Shaw.
Councillor Fergal Leonard.
And Shaw.
Councillor Patricia Logue.
Apologies.
Thank you. Councillor Sean Mooney.
Here.
Councillor Patrick Murphy. Councillor Martin Riley. Councillor Grace O'Neillis.
Shaw.
And Councillor John Boyle.
Just trying to make an entrance. Thank you.
Thank you. Thank you.
Thank you, Pontius. Just going to read out the broadcasting statement. Just this, let everyone know this is the first of the hybrid meetings that there's been in some time. So reading out the statement, I'd like to remind, attention please, gents, thank you. I'd like to remind everyone physically present at this meeting or in attendance remotely that this meeting will be broadcast live to the internet and will be capable of repeated viewing. This broadcast may be terminated or suspended in accordance with our protocol. Due to your attendance at this meeting, you are consenting to be filmed and to the use and storage of those images for broadcasting or training purposes and for the purpose of keeping historical records and making those records available to the public. Members and approved speakers are reminded to only have their mics and cameras on while speaking at the meeting and to use the chat facility to highlight a request to speak. Copy of the council privacy notice may be found on the council website. Okay, just moving on now to item 4, declaration of members' interest. No declaration, and move on to chair's business. I'll just ask Pontius to take this. Thank you.
Thank you, Chair. Members, you will see that there have been a number of late items which were circulated to you yesterday and indeed earlier today, quite recently as well. They relate to the first application that they relate to is item 2, and that is for the small animal incinerator. There are 8 late items, 8 objections have been submitted, and they were issued to you yesterday to advise members that this has been discussed with officers and with the chair, and the opinion and the recommendation is that this application should be deferred to allow consideration and further consultation on new issues which have been raised in those late objections. So over you, Chair.
Thanks, Pontius. Has everybody had an opportunity to read through those late items? I don't know if you don't need any more reading time. So you have recommendations from council officers. Go ahead.
Sorry, thank you for letting me in. Sorry, I just missed when you were asking about the declarations of interest. I just want to note that through my employment through Gary Middleton's MLA office, I received a phone call from a constituent in regarding to the application we're discussing now. But I just want to put on record that I just basically spoke about the planning process and I wasn't lobbied, nor did I give any advice or any guidance on round to the application, but I just want to put it on record that I've had a phone conversation through my employment, but there was no lobbying. Thank you.
Thank you for that. So, as I say, so recommendation there from officers that we should defer this application. That personally I'd be in agreement with. So, hand it over to yourselves. Do you agree with deferring it, or does anybody wants to come back to me? So, from reading the room here, yeah, we're content to defer that application. And to any people in the gallery that have come along to speak on that one, apologise for putting you out, but we need to follow the process. Thank you.
The next item, members, on which you have received a late item, actually received it quite recently there at just before lunch. You received an email, a late item, and that relates to item number 4, and that's L11 2023 1683 for the change of use to a new bar at Waterloo Street. So again, I'll just hand you over to Suzanne here, who'll give a short statement on the position of the officers.
Okay, through you, Chair. Members, so officers have considered the late information, and whilst officers are content, the traffic safety report has been adequately considered in consultation with DFI Roads, and is considered in the consideration of objections under traffic in the report. Officers did advise the agent they would respond in writing to their points of objection, and this was not followed up. So in light of that fact, members may wish to defer this for a month to facilitate officers to issue that response in writing.
Thank you for that. Members, has everybody had a chance to read that correspondence that has just come in, or do you want a couple of minutes to have a read through it? If you can just indicate to me what do you want a couple of minutes to read through it? Councillor Boyle.
Thanks, Chair. No, I've literally just looking at it now, so if that's all right, we can give it a minute or two. Thank you.
So, yeah, sure, we'll take 4 or 5 minutes to read through it. Councillor Jackson.
And no, Gormagh, Chair. And I appreciate the opportunity daily further time for people to read over it. But if what we're being advised is true, I just wouldn't mind a wee bit more information around the consequences of or the different options that are available to us if we do proceed. What's the likely outcome? And just a wee bit more information from officers, because I know, and with all due respect, Chair, you fired at the members to ask how members should proceed, but we're not entirely we're not equipped with what the potential outcomes would be if we do proceed. So I think a wee bit more information from officers around the ramifications of our decision would be helpful. Thanks, Chair.
That's a fair question, and allow Philip to respond to that. And after Philip's response, we can commence reading time then. Thank you.
So members will note that the correspondence indicates that in the absence of a deferral, that there might well be pre-action correspondence that would flow from that, no doubt with a view to a judicial review. As Suzanne.
All right, Chair, I'm struggling to hear the city solicitor. If you could perhaps speak up a little bit.
My belly will only allow me to get so close to this microphone, I'm afraid. So as I say, the correspondence does indicate that pre-action correspondence may issue in the event that there is a deferral. Now, as Suzanne has outlined, we're content that all of the matters are adequately addressed within the case officer's report and have been properly consulted on, etc. However, as an officer team, we believe that the council, if it gives an indication to an individual or to a company and an agent on behalf of an individual, that they will receive written response to legitimate correspondence that they've sent in, that should be done. And so leaving aside any issues in and around the pre-action protocol, it is accepted that we fell short of the standards that we set ourselves in respect of that, and we would like an opportunity to put that right.
Mr. Jackson, that answer your question at this time?
Yes, it does. Thanks.
Councillor Mooney?
Chair, thank you again. Based on that further clarification from the city solicitor and from reading the letter from the solicitors, I'm quite content with that deferral. Obviously, we should err on the side of caution when it comes to things like this. And there was a piece of correspondence that it wasn't followed up and answered. So therefore, there is an expectation that that should be done. So therefore, we should obviously give that time for that to be sorted out, and if there are any replies thereafter. So quite content for this to be put back. Thank you.
Yeah, I just want to be fair to everybody and give everybody their reading time. Can Councillor Boyle, Councillor, it's okay to go with the reading time first and then I'll bring you in then. Thank you. Okay. Members, you happy to, enough reading time on that? Happy to go on ahead? So Councillor Riley was the first to indicate.
Yeah, thanks, Chair, for bringing me in. I had a chance to read this over lunch as well. So just in agreement with Councillor Mooney in relation to agreeing that the right thing to do is to defer this today. And that was my reaction to the correspondence that I had read, but further strengthened by what Philip has outlined to the committee this afternoon. So happy to second Councillor Mooney's proposal. Thanks, Chair.
Thank you. Councillor Boyle?
Thanks, Chair. And in light of the proposal and the seconder, both of whom I agree with, given the information that's in front of us, what would be a reasonable expectation to have this in front of us again? I would be hopeful that we could see this again next month. Would that be possible?
Yeah, through the chair, yes, Councillor Boyle, that'll be our intention to bring the application back next month. If further issues, however, are raised that we would require consultation on some matters, that would be the only reason why it would not appear next month. But we intend to issue the correspondence and bring it back.
Okay, Councillor Boyle. Thank you. Alderman McNorris?
Just to say, I'm happy with their proposed deferment, so we're also in agreement. Thank you.
Thank you. Councillor Jackson?
Sort of, well, bit of sounds of things, this is being deferred, and I can understand the logic behind that. But given the correspondence and some like the correspondence dates back from October 2023, a year ago, and then from April and May. No, there's been considerable amount of time that that's passed since those a correspondence has been sent, and I know, like we want to take decisions at this committee. We've already this is 2 applications that have been deferred already. So it's extremely frustrating that we're not in a position to take a decision here. I'm just posing a question. Is there any possibility of holding a special meeting during the month of October and to consider this? Would there be adequate time to correspond with this client and allow adequate time for a response and still have a special meeting in October? Given that it's there's like this correspondence it originated back over a year ago, so considerable amount of time has passed, and they defer it for a full month may be unfair.
Thanks, Councillor Jackson, for your question. I'm just going to give Council Officer courtesy a month or 2 to discuss response to that. Thank you.
Chair, through you, it's difficult to answer that question definitively today. Obviously, we don't have the information in terms of diaries and so on, and officer availability and everything like that. We'll certainly take those comments on board. We'll go away, and because we're potentially working up towards a reasonably substantial list of applications to be dealt with in November at any time. So if you're content, what we'll do is we'll take that request away and we'll come back to members and let you know whether or not that is achievable. I'm afraid I can't commit to it today.
Okay, thanks for that, Philip. So members, would you be content with, would you agree that it is deferred with council officers coming back with a reply about the possibility of a special meeting on this application? If I could get some sort of indication from all the members, Councillor Boyle.
Yeah, well, obviously, Councillor Jackson has suggested it might be done quicker. And obviously, officers have suggested that they don't know how quickly they can do it. So I suppose, to be reasonable, it would be fair to say if the officer team believe that it can be done quicker, then we can reconvene to hear this particular item. But it's really where we're at the minute is how long is the piece of string that nobody seems to know the length of. So I suppose it's reasonable to proceed in that manner, you know. So that's I think that's fair enough. If that needs a proposal, I propose that we come back as and when we can. And in the event that we can't, then obviously we'll hear it again this time next month, Chair. So I'll make that proposal if that's what you require.
Thank you, Councillor Boyle. Councillor Gallagher.
Thank you, Chair. And just, I think that, you know, we deferred, and I think that there's gaps been identified, and there's a natural justice process to be carried out by officers. And I don't think that we want to give them the impression that we're rushing that. Natural justice has been identified, we sort it out, and it comes back forward into this committee as a natural process. So I think we should leave it at that. I think that, you know, that, no, I'm not even going to that. If the recommendation had been different, you know, it might have been okay, but because it's not, I think we have to give a fair hearing to all and let that process take place.
Thank you, Councillor Gallagher. Councillor Jackson.
No, thanks, Chair. And I don't want to labour on this point, but the fact that the correspondence in relation to this particular client has dated back a year, I find it strange. We are very suspicious that that we received it a couple of hours before we were due to make a decision, and for that very reason, and I don't want to project what might happen in the future, but we have seen a considerable amount of late information that's been submitted in the day and the day prior to us taking decisions on applications, and if we're going to maybe if there was a potential opportunity for a special meeting, it might help, it might help combat a tactic around late information or any stalling tactics that might be that put forward in terms of any application. So I just in terms of the timing of that that particular piece of correspondence, it does concern me, but it might be it might be a coincidence. So that was me thinking around the potential opportunity for a special meeting to avoid that tactic being deployed. Thanks, Chair.
Okay, thanks for your comments, Councillor Jackson, and I'm sure everybody in the chamber has heard them. So again, just make sure we're all in agreement here. I can have an indication from all the committee that we're content to defer this. Yeah, okay, thank you. So this particular application is deferred today, and once again, apologise to anybody who's come to hear this application today, but you've heard the arguments for the deference, so thank you. Can I just go through a running order now? There's one more, sorry, excuse me.
And members, finally, on the late items, regarding item number 3, which is LA 11 2023 1649, which is an outline application for a dwelling at Tamnearan Road Cross. You have yesterday been sent yesterday and today, 2 late items, 2 emails of support from Councillor Norris and Councillor Duffy. So they are with you. Thank you.
Well, okay, members, we'll just confirm a running order there. It'll be item 1, the Lisky Road one, and also number 3 there for the Tamnearan Road. So we'll move on now to LA 11 2021 084 bar 0, and Suzanne's taken us through this one. Thank you.
Thank you, Chair. Good afternoon, members. Item number 1 is LA 11 2021 0854, proposed infill site for dwelling and garage, approximately 75 metres north of 40 Lisky Road, Bairnie Victoria Bridge, and the recommendation is to refuse. So as outlined in the reports, members, this application was previously presented to the Planning Committee back on the 7th of June 2023 with a recommendation to refuse for the following 2 reasons. Contrary to CTY 1 and then contrary to PPS 2, natural heritage issues in relation to impact on protected and priority species. Members did resolve not to accept the officer recommendation in relation to refusal reason 1, which is CTY 1, and then members agreed to afford the applicant an opportunity to resolve the access and the ecological issues in relation to refusal reason 2, following which it was agreed to return to committee. So we are now back with all the information being received. We've had an amended access position and further information. We've had 10 attempts at further information being submitted since the 7th of June 2023, and officers are now content that resolves the access and ecological issues. Just focusing on that issue at the minute, the issue was basically the earthworks required to lower the roadside bank for the visibility displays, and the access was going to impact on a number of mature trees. So the amended proposal indicates the access position moving slightly further to the east, and we have further reports that have been submitted which remove those natural heritage concerns. So officers are content in line with the statutory consultees that there'll be no impact on priority habitat species or bats. And that's just a slide of the proposed site plan. And a photo there on your of the trees to be removed and then the trees to be retained. And again, more details of what's been removed. They're very, very mature trees, so we have come a long way in terms of retaining and protecting the ecological issues. So that still leaves the first reason for refusal, CTY1, and clearly the application was presented back on the 7th of June 2023. So looking at those matters again, you can see the site on the location map outlined in red. Sits well above the Lisky Road there. You can see the elevations. There's a panoramic photo at the top, and then just a photo taken from the junction with a mature tree. The policy context as listed in your report remains the same. PPS 21 being the determining policy context, and the consultation responses, no issues have been raised, and no letters of objection or support have been received. This is just a plan and history map, just showing the area, and there was a planning approval outlined in green. Nothing has been built on that site, though there are foundations that are have been put in, but they have not been certified that they have commenced within the time period, but there's no building on the ground. There was an issue in terms of an adjacent listed building. Historic environment or historic buildings had relayed concerns to us, but officers consider that the site is approximately 200 metres northwest or it was within 80 metres of the site, the listed building. It's not intervisible when viewed from the Lisky Road, and we felt that there was sufficient separation distance, and there would be no issue in terms of PPS 6 in the setting of the listed building. You can see the distance just viewed there in the photo on your screen. So in terms of CTY 8, its officers view that the proposal will not create or add to urban development, and therefore the exception within CTY 8 is not engaged. So that is the starting point. The site in the larger field provides a substantial break between the buildings along that side of the Lisky Road. There's gaps, quite large gaps on either side of the site. There's no substantially built up frontage. And you can see in the map there, just explains it a bit more clearly for you. Large gap to the south, garden area, house, further gap on. So its officers view that there's no substantially built up frontage. Just some photos there, just illustrating that there's no buildings that are intervisible with the site. And in terms of a more detailed consideration in terms of the buildings that are along the Lisky Road, the site is not considered to be small. Its frontage measures 63 metres, which is significantly larger than the roadside frontage of the buildings at number 40, 36 and 30 Birney Road and the Birney Nursery. So that is just the agent's submission that has been put in, which clearly shows the two gaps either side of the site. Couldn't be considered as a small gap within a otherwise substantially built up frontage. So in summary then, members, in consideration of the details put out or laid out in the report, officers remain of the view that the application does not meet policy CTY 1 of PPS 21, and there are no overriding reasons why this development is essential in this rural location. Thank you.
Thank you for that, Suzanne. We have Mr. Brenton Johns online. You there, Brenton?
Yes, Chair. Can you hear me okay?
Yes, we can hear you. You can go ahead there now, and you have 5 minutes speaking time to address the committee. Thank you.
Thank you, Chair. This application was previously considered by the Planning Committee of the Council in October 2003. At that meeting, the planners presented 2 reasons for refusal. The first, that the proposal did not meet any of the cases in which an individual dwelling would be permitted in the countryside, and the second was that it had not been demonstrated that a dwelling on the proposed site would not adversely impact on the priority species and habitats. The applicant put forward a case that the proposal did represent a development opportunity, and the Planning Committee at that meeting resolved to accept that the proposal did indeed represent a development opportunity in the countryside. Now, this is recorded in the Derry and Strabane District Council Planning Committee report on the 4th of October 2003 and is recorded at the bottom of today's committee report. The dictionary definition of the word resolved is to settle successfully or to declare and decide by formal resolution and vote. With regard to the second reason for refusal, the committee afforded the applicant an opportunity to resolve the issues in respect of the potential impacts on protected and priority species and habitats. These issues costing the applicant in the region of £1,500 have now been favourably resolved and is not now an issue with the planners. Consequently, they have now removed the second refusal reason. As both reasons for refusal have now been positively resolved, we would have expected a decision to approve this proposal to be represented to the Planning Committee today. Therefore, it is with some surprise that the planners have appeared to disrespect the Planning Committee's original resolution to accept the principle of the proposal and have again returned this proposal as a refusal. In the case of the refusal reason one, we're going over old ground again. Contrary to the Planning Committee having resolved the issues, at the 2023 meeting, the planners have resurrected the notion that the proposal does not meet any of the range of types of development within policy CTY1. The committee had agreed that the proposal could be considered as an exception to ribbon development and therefore satisfy policy CTY8. It is also the responsibility of the planning authority to assess development proposal against all planning policies and other material considerations that are relevant to it. The SPPS that will inform the Council's new local development plan states at section 6.69 that the aims, objectives and policy approach must be to cluster and consolidate and group new development with existing established buildings where it can utilise existing services such as drainage, mains, water, etc. It appears that no weight was given to this SSP policy approach by the planners. So considering the other planning policy and material considerations, in addition to the CTY8, we put forward the argument that because of the uniqueness of this case, that is the existing cluster of buildings within this rural settlement, the associated footpath and public lighting infrastructure, the 40 mile/an-hour speed limits, the post boxes, etc., all of these been linked to the workers' cottages and footbridge which serve the herdman's mill. Clearly, modest design dwellings can be visually and physically absorbed within the existing cluster through rounding off and consolidation, and will not significantly alter its existing character or visually intrude into the open countryside. So being absorbed into the existing pattern of development, the cluster will appear as a visual entity in the local urban style landscape and therefore meet the objectives of the SPPS and regional development strategy. As we know, the Planning Committee accepted this interpretation of policy on behalf of the Council, and it would be expected that the planners, also a Council body, would respect and honour this resolution reached through a democratic vote. The report by the planners to Council Planning Committee today clearly states at the bottom of page 1 that the committee resolved not to accept the officer's recommendation to refuse, and that subsequent information submitted with regard to refusal 2. We would contend, therefore, that despite the apparent resistance by the planners to accept the committee's previous resolution in relation to refusal 1, we would respectfully strongly suggest the Planning Committee are now in a position to formally approve this proposal. Thank you, Chair.
Thank you, Brendan. If you could just remain there where you are, and just want to ask the committee members if they've any questions for you. No, Brendan, it doesn't seem there's any questions here, so thanks for your attendance at the meeting today.
Thank you, Chair.
Okay, members, any questions for Suzanne, please? Councillor Devine.
Thanks, Chair. I don't know whether Suzanne will be able to specifically answer, but I suppose it's that query in relation to the June meeting and the fact that members did resolve to overturn the officer's decision in relation to refusal reason 1. And what position does that leave us in now, that the fact that has already been resolved?
I think Philip's going to go with this first.
Yeah, members, so that the position is settled in that a decision in respect of a planning application is not final until such time as the decision is formally notified by the issuing of either the green form or the refusal notice to the planning applicant. So at any time up until that point, the matter can be brought back before the committee for further consideration. It's not uncommon for that to happen as a result of material new information being received in respect to the matter. So the any resolution in respect of this matter or any I'm loath to use the word resolved because I'm not 100% convinced that that's necessarily the right terminology in respect of this, but any indication that the committee might have given back at that time is not binding until such time as the green form is issued or the red form is issued.
Councillor Devine, that answer your query, all right? Okay, have we any other questions for Suzanne or any of the panel? No, nobody's indicating. So committee, there's a recommendation there from planners to refuse this, so I'll pass it over to yourselves now for anybody, any further comments or proposal. Councillor Gallagher.
Thank you, Chair Flitton. Chair, issue 2 resolved. I'd like to propose that we revert back to the original decision of this committee and the reasons given back then. Thank you, Chair.
Yes, we can take a proposal. Councillor Boyle.
Similarly, Councillor Gallagher, completely concur, and I'm happy to second that proposal.
Okay, members, we have a okay, then. So there's a proposal there from Councillor Gallagher, second by Councillor Boyle, to overturn the planner's decision and permit this application. Is everybody in agreement? No dissenting voices, so thank you for that. So members, committee's overturned that decision and allowed this application. Thank you. So members, we're going to move on to number 3, SLE 11, bar 2023, bar 1649, bar O, and this is a Tammany Hearing Road application, and Laura's going to do this one. My apologies, Molly's going to do it.
Thank you, Chair. Good afternoon, members. I'm sorry for the delay here. The next item is L11, 2023 1649. It's an outline application for a proposed site for an infill dwelling at a site adjacent to 149 Tamnian Road Cross. The recommendation before you is to refuse the application. So the application site is an irregular shaped roadside site located off the Tamnian Road. It's adjacent to an existing pair of semi-detached properties, which are roadside, and there's a bend on the Tamnian Road. The site itself is the northwest and western boundaries are defined by mature hedgerows and trees. The eastern boundary is defined by a fence which is adjacent to 149 Tamnian Road, and the application site will be visible when travelling along the Tamnian Road from the east. And when travelling from the west, it will be obscured by the existing copse of mature vegetation. The application site lies outside any development limits and therefore falls to be considered any development that's defined in the area plan and therefore is considered countryside and is considered under the planning policy PPS 21. The application site is just to give you an indication of the area. There's an ortho photograph of a site. The site is this irregular shaped site, and the mature copse of trees is indicated in the report and referred to is here. You have the pair of semi-detached, known as 149, 147, which are roadside. And I suppose it's important to know for the consideration of the report, the location of number 153 Tamnian Road, which is this site back here. And that's just a photograph of the actual site itself. It's just a field at the minute. There's no significant features within the actual site itself. So the relevant policy context is set out in the planning officer's report. Includes the RDS, the Dairy Area Plan, the SPPS, PPS2, PPS3, PPS6, and PPS21, as well as supplementary planning guidance, building on tradition. There are a number of bodies consulted in relation to the application. These include NA Water, DFA Roads, Environmental Health, and Historic Monuments Division. As you can note from the case officer report, there's no objections raised subject to standard conditions and informatives from any of the consultees. In terms of planning history, a similar proposal was submitted and withdrawn back in 2022. So in consideration of the application, the main policy consideration is set out in PPS 21. And in this particular case, in CTY 1, we're directed towards CTY 8, given the applicant's case that this is a proposed infill site. So the first aspect to consider for officers is whether there is a creation of urban development. In this case, the new dwelling will read with 147 and 149 Tamnian Road and would create a urban development. Therefore, it engages the exception test, which is outlined in CTY 8. So officers have considered each part of the exception as outlined in CTY 8, which allows up to 2 dwellings within a small gap of a continuously built up frontage. The application site itself is considered road frontage onto Tamnian Road, and also the pair of established semi-detached bungalows that's known as 147 and 149 are also considered road frontage on the Tamnian Road. The fair property being relied upon for the continuously built up frontage is a number 153 Tamnian Road. This is set back some 210 metres from the road. There's a 2-storey dwelling garage, which was a replacement dating back to the late 2000s. That does not share a common road frontage to the Tamnian Road and is not visually linked with the existing dwellings. And therefore, officers consider that it doesn't meet the test of being a substantial and continuously built up frontage on the grounds that number 153 does not have a road frontage on the Tamnian Road, and therefore there isn't free buildings within a small gap. In terms of the small gap test, officers have also considered the proposed road frontage is not comparable to adjacent semi-detached dwellings, which have a site frontage of approximately 18 metres and 45 metres each. And as says, 153 Tamnian Road, which is a width of approximately 50 metres. And therefore is not considered to be a small gap within a substantial and continuously built up frontage. Officers have also considered whether there is a loss of visual break and a negative impact on character in this particular proposal. The loss of this visual break through the introduction of a proposed dwelling would create a ribbon of development and therefore result in a material change in the appearance of the locality. It would harm the rural character of this area. We've also considered the other relevant policies within PPS 21, including CTY 13 and 14. Whilst officers are satisfied that a property could integrate and meet the test of CTY 13, given that there's a suitable degree of enclosure at the site to integrate a modest dwelling, we considered in terms of policy CTY 14 that there would be an adverse change in the rural character as a result of the creation of urban development and the creation of a suburban style build-up development, which is considered detrimental to rural character and therefore contrary to CTY 14. We've also considered CTY 16 within the report. In terms of all our relevant planning policies, PPS free, we've consulted roads, and the agent has submitted adequate plans, and roads are content subject condition, which could be met at reserve matter stage. We have no concerns in terms of residential amenity, given this can be considered a design stage at reserve matter stage. In terms of PPS2 natural heritage, it's not, the site is not located within or adjacent any nearby water courses. There is no ecological features observed on the site, other than the hedgerows at the front, which condition can be provided to mitigate the removal of the hedges to be replaced by new planting of native hedgerows along the new road boundary. The details of these can be submitted at reserve matter stage for consideration. There was a record of historic monuments in the locality. We have consulted Historic Monuments Division, and they're content with the proposal satisfies PPS 6. We received 2 letters of support as lead items, and within these letters of support, there was references to 2 recently approved infills on the Tamnian Road, which have been raised as precedents that ought to be given weight in the assessment of this case. Officer's opinion, as always, is that each case should be assessed on its own merits against the relevant policy. The circumstances of each case are different, and the case before committee, officers are satisfied to assess it against the relevant criteria in CTY 8 and are content that there's sufficient reason to conclude the proposal does not meet the necessary policy requirements. So in conclusion, having considered all material considerations, including the development plan, the relevant plan policies, consultation responses, officers recommend refusal, and the refusal reasons are set before you and also within the case officer's report. Thank you, Chair.
Thank you, Malachy. Just my notes in front of me indicated speaker was Councillor Alex Duffy, but I can't see him here in the chamber. I can't see him online. Maybe he's having difficulty getting online. But was he here, was he?
Yeah, maybe somebody should go out and have a wee look for him.
Thank you.
Maybe hang
Thank you.
about.
Okay, members, just clarified there that Councillor Duffy is content with this letter of support that he's put in. So moving on now, I'd ask Mr. Boyle to come forward to address the committee. Thank you. So, Mr. Boyle, you're very welcome to committee today. And Mr. Boyle is going to address the committee on behalf of the agent. And you have 5 minutes starting from now. Thank you.
Thank you, Chair, for the opportunity. We would hold that this application does satisfy CTY 8. The application site satisfies CTY 8 for infill dwellings. It's a small gap site and otherwise built up road frontage. The infill opportunity does exist between numbers 147, 149 and 153, which Malachy correctly points out is set back. But the policy does allow for infill when dwellings are set back, and this has been tested at a judicial review and is shown as examples within building and tradition, a document that the planning office rely on quite a lot. There is a sufficient space to accommodate a dwelling of similar size and scale to the adjacent properties on a site which is similar in size and scale. Now, as Malachy points out, it is an irregular shape. So when we take the irregularity out of the site, it would be a similar size to what's there. There is no detrimental impact caused by the development. No backlands will be sterilised, nor accesses will be adversely affected. The site has a common frontage, and CTY 8 5.33 allows for infill opportunity, as I said earlier, whenever sites are set back or staggered. The pattern of the existing dwellings and orientation of the frontages accommodates the infill, which is not affecting the rural character of the area. The outbuildings and farmyards adjacent at number 153 frame the boundary of the infill site. This pattern of development mirrors closely the recent approvals at Tamlane Road. In fact, they're virtually similar, which is LA 11 2018 0741 at 170 Tamlane Road, and LA 11 2021 0386 adjacent to 149 Tamlane Road. Also, LA 11 2019 0407 220 Tamlane Road. The previous application was submitted as a cluster. This was an incorrect application because infill is the correct one to use in this one. Even though there is clustering there, it's not clustering as would be identified under the policy. So we hold that under the justification of the policy, there's no detriment to character, amenity, nor appearance. Backlands will not be sterilised or hampered. The site is a rounding off of an existing gap site. 5.33, the site is located off a public road. This is agreed by the case officer's report, where the existing dwellings are visually linked. Again, this is agreed in the case officer's report. The gap site is not a visual relief break. The existing pattern development will allow for a dwelling to integrate successfully. Under integration, I think Malachy has conceded that integration is an issue. The site does visually integrate into the surrounding landscape. The new dwelling will not be prominent. I think the points that I raised in this, Malachy has already conceded these. The site has established natural boundaries, doors given closure. There's no reliance on new landscaping. Ancillary works such as the laneway will not affect vegetation. Adjacent dwellings are of a mix. The proposed site can easily accommodate a new dwelling. The site blends with the local landform. Under character, we would argue that the site is not prominent. The landscape, as it is currently set, is well screened at a distance from the public road. The site is not suburban. It is traditionally rural in character. As almost staggered across the road, there's a very similar case. The parallels are very, very similar. And there's no breaking of character with it. We would argue the same with this one. The site respects traditional development pattern and reflects the established pattern available on the Tamlane Road. There is no...
Just ask you to bring your comments to conclusion now.
All right.
Thank you.
So all the consultees are happy. We have at least 7 relevant precedent cases, all post, I think it's post 2019 that we can bring to it. But we would argue that the judicial review has proven that you can have a setback property which will form the framing of an infill.
Okay, thank you. Thank you, Chair. If you just stay where you are, I just wanted, committee members, any questions there for Mr. Boyle? Oh, I'm not seeing any questions here. Thanks very much for attending the committee today.
Thank you.
Okay, members, has anybody any questions for Malachy? Councillor Devine.
Thank you, Chair. I just have a question for Malachy, and Mr. Boyle's referred to it there, and it was a query I had myself in relation to CYT 8 and 5.33. And it does say there, for the purpose of the policy, a road frontage includes a footpath or a private lane, and that the buildings sited back, staggered or at angles will still represent urban development if there's if they have a common frontage. So could you maybe explain why you would consider that not the case then for 153?
Yes, through the chair. Yes, in relation to the policy, yeah, 5.3, when it's talking about footways or pathways, where the dwelling fronts on that footway or pathway, that can be taken into consideration. Officers, if we look at the last sentence in the second paragraph of CTY 8, says for the purpose of this policy, the definition of a substantially built up frontage includes a line of three more buildings along a road frontage. So we consider those buildings have to be on the same frontage, where the 5.3 is referring when there's buildings on a frontage. So you can have a building staggered back, but in this case, it doesn't have a road frontage. It doesn't front onto Tamnian Road as such, the curtilage of the property. So it can't engage that last part of the last sentence of the second paragraph.
Councillor Devine, and you want to add to that?
Sorry, I'm still not clear on that because it does say footpath or private lane. So am I reading would be that house 153, there's a private lane into that house which is fronting onto that road?
Yeah. So the two words are linked here. So if you link the word road frontage within the grey, so we must assess whether there's free properties on that road frontage. So in officer's opinion, in paragraph 533, for that first line, there may be instances where there's free properties along a laneway, which creates a ribbon. So you can have a ribbon going back up a laneway, and they're sharing a frontage onto that private laneway or footpath. In this case, the road frontage is Tamnian Road. So there's only two properties with the frontage on the Tamnian Road, where number 153 is back and its curtilage is set back 210 metres. If the other two properties had been on the laneway, we could, you could have, and they were accessing onto that laneway and fronting on that laneway, and they read as a ribbon, we could have considered that's where that part of the policy could have been allowed, in our opinion.
Anything else on that, Councillor Devine? No. Okay. Anybody else, any questions for Malachy? Councillor Boyle?
Just a brief one, Chair. Thanks a million. There was mentioned by the agent of a judicial review somewhere up the country, as my memory serves me. Are you familiar with that particular case and how might it relate to this one, or have we got an idea on that?
So I don't have the details, Councillor, before me, so I couldn't comment on it.
Councillor Boyle, what I'm going to do is ask if the agent has that answer to your query, and if you'd be willing to share it with us.
If we could ask the agent to come back over to the microphone, Chair, if you're ruling, but that's what I would have suggested. Yeah, thank you.
Thank you. Second, Mr. Boyle. Yeah. Thank you. Did you get the question all right there that Councillor Boyle was asking?
Thank you, Chair. I did. The judicial review is East Road, Drumshurn. We were involved in the fighting of it. I think we shared some information with the city solicitor at the time, and the whole argument was whether it was very similar to this, when did it stop becoming road frontage, and when was it road frontage? And we successfully argued through that the laneway was the access to the house. So that was, you couldn't get to the house that was set back. And that fought its way right through leave hearing, appeal, and back to High Court. So it was a dogged fight.
You've when that was, any idea, month or year?
We only got the decision, I think, was March, April this year.
I'll just invite Councillor Mooney to read out what he is. I take it that's online there.
What I find online is there's a judgment, Gordon Duffy, Causeway Coasting, Glensburg Council, and Alex McDonald seems to be East Road, Drumshurn. Citation is KEE 12122, and ACOS is 21 whatever. It was 2023, NICA 22 is a citation, Board of Appeal.
Read out the citation.
Seems like. Copy that. Send to Philip.
Come on, nice.
Send to Philip.
Right on.
Paste. Don't worry about that. Sure.
Members, what I suggest, we're just going to take members, you can just give your best attention. We'll just take a break for 5 minutes. I think this is important, and we'll get this information for everybody in the committee. Thank you. Go ahead, Mr. Boyle.
All right, Chair, thank you. This kind of development is also shown in the Building and Tradition Handbook, where houses are shown along the road edge, and maybe the third house is shown set back and not directly accessed.
Yeah, thank you. You're free to go now. Okay, members, with Councillor Boyle.
Just briefly to explain, the reason I asked the question is because I think that was the line of territory that Councillor Devine was going into as well. So I think it's important that that's given due consideration, and we do come back to it in 5 or 10 minutes.
Okay, members, we'll give it 5 minutes and we'll come back to this point. Thank you, everyone. hand over to Philip at this stage.
Yeah, thank you, Chair and members for the time in relation to this. I've sent through to members a copy of the judgment to which Mr. Boyle's referring, and you may want to take a minute or two to consider it. I'll just direct you to a couple of the paragraphs in relation to this. I was a little bit confused by this one initially because, of course, members, we've referred in our training to the East Drumcerne case on a number of occasions. It's the case which the reference to planning committees not living in the world of Humpty Dumpty comes from, if you remember that particular one. The history of the case is that whilst there was some discussion of the merits in that application originally, that case was initially decided on the grounds of standing, as to whether or not Mr. Duff had standing to deal with it. And Mr. Justice Schofield threw the case out on the basis of Mr. Duff not having standing. Mr. Duff took that case to the Court of Appeal and was successful in the Court of Appeal in having the case reinstated on the basis that it was determined by the Court of Appeal that he did have standing. And the matter was then referred back to Mr. Justice Schofield for further consideration, again in relation to the merits of the case. Now, where I think perhaps the confusion is arising in relation to this matter with the applicant's agent is that whilst Mr. Justice Schofield determined that the merits of the case were that the application would be refused on the grounds, amongst other things, to do with the issue of road frontage, he decided that he would not quash the planning decision, the planning permission that had been granted by the council because of the long history and issues in relation to standing and so on. So whilst he actually found that on the merits of the case the planning permission should not have been granted, he wasn't prepared as a matter of remedy to take the planning permission that had been granted away. Members, in terms, and sorry, Councillor Murphy, I couldn't track your email down, so I haven't sent it to you yet, but you can either look on there, and Chair, I have yet to send it to you as well, so I'll do that. But members, you'll want to look at paragraphs 29, 29A, which is on page 9 of the copy that's been sent to you, where it says the curtilage of the property ends some 25 metres back from the road edge where it accesses onto the laneway. It is only the laneway which meets the road, and the access to number 51 beyond the gates in the lane is well back from the road on which the application site and other houses do have frontage. The officer was simply right as a matter of fact and or a matter of application of the policy to say that as the curtilage of number 51 does not have a common frontage onto East Road, it cannot be taken to form part of a substantial and continuously built up frontage along East Road. And he then goes on to discuss how that is consistent with decisions which have been made by the Planning Appeals Commission. And then members also then further on down at paragraph 30 at the top of page 10, he goes on to say this misunderstands the distinction between ribbon development on the one hand, which is prohibited, which can take into account buildings which are set back from the road and which are visually linked to other buildings, and a continually built up frontage on the other, which is a necessary element for CTY8 to apply, in respect of which no such concession applies. In other words, in relation to CTY8, houses that are set back from the road cannot be taken into account. And finally, members, I will direct you as well then to paragraph 52, where he then says, for the reasons given above, I consider that the council was wrong to grant the planning permission in this case in the way that it did, particularly in light of the previous decisions, refusal decisions or recommendations. The grant of planning permission represented something of a windfall to Mr. MacDonald. And he goes on to say that if Mr Duff had objected during the planning process, during the course of events may have been different, the permission may not have been granted. He says that paragraph 53, in my view, the council was right to concede the substance of Mr Duff's challenge, i.e. that the permission should not have been granted because of that issue. So, Chair, a matter for you and for members, obviously, if you want a little bit of time to consider that. But members, factually, the position is that that judicial review is in fact an authority for the fact that in terms of CTY8, these houses that are set back cannot be taken into account in consideration of a substantially continuity and built up frontage. And again, the recent Court of Appeal case, which we've discussed in this chamber before, agrees with that position.
Thank you for that, Philip. Members, I think it's important that everybody has an opportunity to read through that. So I'm going to say that we'll take a recess until 20 to 4. That's about 12 minutes or so. So if everybody's had an opportunity to read through that, or if you indicate to me before that that you understand it, we can progress. Thank you. I hope you find that recess useful to read through that. Has anybody any questions for Philip at this stage? No. Has anybody any questions for Malachy? No. So members, so we have a recommendation from officers to refuse this application. So hand it over to yourselves if you have any further comments and if anybody has any proposals. Thank you. Councillor Boyle.
Thank you, Chair. Chair, in light of the information that we have, had the opportunity to look through, I propose that we accept the officer recommendation. It's clearly a complicated situation. I think we've given it fair wind. However, the information in front of us suggests to me that the officer recommendation is the correct recommendation, and so therefore I will propose that we accept that recommendation.
Anybody to second this? Councillor Gallagher. Can I have a seconder then? Alderman Morris, sorry. Go ahead.
Sorry, I was just going to commend you second proposal, but I think, did you come in, Paul? Were you going to second it? No. All right, happy to second it.
Okay, is anybody else wants to make any comments on that? Okay, is everybody content with the proposal? Any dissenting voices? No, so then we are accepting the officer's recommendation to refuse. Thank you. So we're moving on to agenda item 9 is a list of decisions. They're there for your information. And item 10, the appeals update. Has anybody any comments or queries on these? No, thank you. Just Philip wants to say something here.
Members, it's just to update you. It was too late to go on to the agenda in relation to it, but you may remember, members, we had a judicial review of a decision in relation to a replacement dwelling, which arose out of the dual carriageway works at the A6. It was a matter that was heard almost 2 years ago. We've been waiting for judgment in relation to that. Judgment was handed down just within the last week in relation to that matter, and I'm pleased to say that the council was successful on all grounds, and costs have also been awarded in relation to the matter. I'll bring a report with a copy of the judgment to the next council meeting, or next committee meeting.
Okay, I can't see any other indicator speakers, so I'll bring the meeting to the close. Councillor Jackson.
Chair, and if just to beg your indulgence, it was in relation to the final application. I just want to point out my appreciation anyway for the way it was handled, because it was a very complex case. There was legal judgments that were discussed through the deliberations, and I think it was the right call to allow time to consider that. And I just want to pass on my appreciation to yourself for allowing us that and helping us come to a more informed position in relation to taking a decision. So I appreciate the way that was handled, Chair. Thank you.
Thank you, Councillor Jackson. I appreciate that. And
Chair, if you don't mind, I think we could all concur with that. I think we all agree with that, and appreciate your time and your indulgence as well in relation to it, because as Councillor Jackson said, a complicated situation. So again, from myself and I'm sure others as well, much appreciated.
Oh, no problem. Thanks very much, Councillor Boylan. Safe home, everyone. Thank you.